Welcome back to the channel and thank you for watching. In the last 24 to 48 hours or so, I've had a number of conversations with a number of people who say they are sure of someone's guilt, or they are sure that something happened because, and then there's a whole list of reasons. Either they've seen it in the news, they've heard of lots of people making complaints, or any one of a number of reasons that have justified why they are sure that a certain thing happened in a certain way. And so, without naming anybody, I'm going to say that as a barrister and as someone who has been in and out of court fighting and defending these sort of cases, I can say to you that you are not sure. And I say that quite boldly for a very good reason. And that is because we have a process and we have a system, we have an evidential system whereby the case needs to be fought and defended, whether it's a criminal trial or a civil trial. And unless you have been in the position either of the judge or the jury, depending on which jurisdiction and which type of case is being heard, but unless you are in that position and unless you have heard all of the evidence presented, both for and then tested and then against, and I make the distinction quite clearly, because evidence for one party is their primary evidence, their evidence in chief, or their presented documentary evidence, or something else. Then that evidence needs to be tested by way of cross-examination. For example, sometimes a witness will tell you that I've just been asked to talk about this, but they haven't then really been able to respond properly to their tested evidence. And so when their evidence is tested, actually it doesn't really stand up to scrutiny. But you, again, would probably not have heard that testing of their evidence. And then secondly, all of the evidence presented against that case for the defence, which can often very much seem a bit random to someone bringing a case, because the defence can usually bring a lot more evidence in than they would expect. And then, of course, if that's properly defended and you've heard both sides, I always say that if you were sitting, let's say it was a criminal trial and a prosecution, I always say that you should, after the close of the prosecution case, you should feel absolutely convinced that this person is guilty of this offence once you've heard all of the prosecution case. However, then when you've sat through the entirety of the defence case and heard their closing speech and so on, you should be equally convinced that there's no way they could have done this, certainly not to the criminal standard. And absolutely, they cannot be found guilty beyond a reasonable doubt that you are sure that they are guilty of this offence. And then you're supposed to go back to the jury room and think, what on earth do I think now? Now that I'm equally convinced they did and they didn't commit this offence. And that's why you can't be sure without having been through that process, because that's a very careful, tried and tested process where you have to sit through both sides of the evidence, for and against. You weigh them up, and we ask and we lean on the jury to fill in the blanks between the law and the process and come up with the real life intuition, that human lie detector element, and really put together the result, the verdict, based on all of the evidence, equally fought and defended. And unless you do that, you cannot be sure. And so when something is reported in newspapers, for example, very often they will simply report on what has been said to the court, maybe in an opening speech. But an opening speech is not evidence. It's just what the court's been told in the opening speech. So whilst it is an accurate account of what's been said in court, and that's as far as it goes, you should not be convinced by that just by what you read in a newspaper, because unless you have, as I say, been through the entirety of the trial and then you come to a decision on it, you can't be sure of what's happened. You can't be sure of whether one party is guilty or not. Equally, if you've just seen in the news that someone has been accused by a number of different people, again, you cannot be sure, because just because a number of people say so doesn't mean that it necessarily happened. So as a lawyer, as a barrister, I would urge you, when you hear things like that, even if it's in a newspaper, you should almost treat it as though you've heard it from a friend or from somebody else, because unless you've been through the entirety of a trial which is properly fought and defended, you cannot be sure. So that's my message for this video. Take everything that you hear with a slight pinch of skepticism and just think, what if? Have an inquiring approach about it. Have in your mind, as we do as lawyers, what would you do or what would you think if you were on the other side of this argument? What would your argument be against what you're reading? What would the flaws be? What would the alternatives be? And the chances are those alternatives are part of the other side's case, which you probably didn't read about, or you probably didn't hear about. You probably just heard the explosive news, which is XYZ person has been accused of ABC thing. Again, whether it's civil or criminal, that's what you've likely heard. You have almost certainly not heard the entirety of the case. So that's my intuition for you today. I hope you found that an interesting way of looking at it. I hope it changes the way you look at things as you walk around and you read things online or you hear things from friends. And equally, if you hear a story from a friend, think to yourself, that's hearsay, especially if they're telling you what someone else told them. It becomes multiple hearsay, and that's what we call rumors. And there's a reason you shouldn't listen to rumors. So I hope you found that interesting. Please like the video and subscribe. And as always, thank you for watching.